Okay, folks, let's begin. Let's start by acknowledging and celebrating the first Australians on whose traditional lands we're meeting today and pay our respects to their elders, past, present, and emerging. We're very, very excited. Damien and I are very excited to welcome Damien, Dr. Damien Clifford today, who is a senior lecturer at the ANU and an associate researcher at the Information Law and Policy Centre at the Institute of Advanced Legal Studies in London. His research focuses predominantly on data protection, privacy, and regulation of technology, and today he will be speaking on artificial intelligence and sensitive inferences, new challenges for data protection laws. So we'll hear from Damien, and then Joe Ford will act as discussant afterwards. That's why I was hanging on a little bit, because I think Joe's coming straight from teaching, but he will be here. In case he's not here, have your questions ready. But I think you're going to speak for about 35, 40 minutes.
Yeah.
Great.
Thanks, Jess. All right, well, thanks everyone for coming. So as you can see, this is a book chapter that I've written with Megan Richardson, who's a professor at Uni Melb, and Norman Wietsip, who's at Monash, although now he's moving, I think, to Hong Kong. But so it was something that we've been considering for a little while. Actually, when I first arrived in Australia, we started talking about this topic. And it's forthcoming in the book that Joe and Dylan are co-editing, along with some colleagues at SMU. So I thought to begin, I'd just kind of lay some groundwork so that we're all kind of working off the same kind of understanding, and just to kind of explain where the problem question came from. So AI, it is on artificial intelligence and sensitive inferences, and then the blurring of categories of protection that are in data privacy laws, so the personal data and sensitive data categories. But to start out, I thought I'd just kind of explain what I mean by AI, and just, I suppose, focus in on two aspects of it that will kind of help you understand where exactly the problem question is leaning and what we're trying to answer. So AI, or more narrowly machine learning, allows for prediction and classification of phenomena. And it's really those kind of prediction and classification that I want to focus on. So you have a training data set that can be labeled, and the learning aspect is relating to software that is written in a manner that allows for varying degrees of human intervention. But it's the fact that AI, or machine learning more specifically, is designed to predict or classify phenomena, based on training data. And to explain what we're looking at a bit, I've got a few different examples. So this one is from, I think, about 4 or 5 years ago, where there were news reports that Facebook had said that it could identify teens feeling insecure and worthless. So obviously it was doing some degree of inferring, prediction or classification based on data that it has on those using the platform, which was quite worrying. Obviously, given the fact that they were talking about people who were feeling insecure and worthless, and on top of that, that they were young people. And Facebook is kind of like, there are a lot of examples with Facebook, because generally they tend to do things quite badly. So you have the Cambridge Analytica example, which is another one that is obviously, I think all of you will probably be aware of it. But obviously it was like the prediction and classification and prediction of different, I suppose, insights in order for political purposes that time, for political advertising purposes, in order to sway public opinion. So that was with the Brexit referendum and with the Trump election. Another one would be, which kind of harkens back to the research that I did in my PhD around emotional AI, or emotion detection technologies. So technologies that say that they can detect emotions. Now I say they can do that, but there's quite a lot of I suppose people who dispute that quite a lot. But I mean, they're predicting the emotional state of someone based on signals that are gathered by this smartwatch. And I suppose that we, working on the basis of those technologies, that led us to this question. So what do these sensitive inferences, because they are sensitive, if you think about the outcome that can happen from their detection and what they're actually getting to, be that kind of, your mental well-being, your mental state, or how they can potentially direct you in terms of your political leanings, what does that actually mean for the category-based protections that are afforded in data privacy legislation? And as I mentioned before, What I'm referring to here is the fact that in lots of pieces of legislation around the world, you've got two different categories. So you've got personal data information, and then you have these sensitive categories of data. So if you can infer on the basis of fairly innocuous data, very sensitive attributes about someone, what does this mean for this traditional void within regulatory regimes? So that's the fundamental question that we started with. But in order to kind of give you a bit of a grounding on what the legislation looks like, I'm going to just kind of give you an overview of what definitions of personal data or information look like. And we're going to look at the GDPR, which is the General Data Protection Regulation in the EU, and the Privacy Act in this jurisdiction, so the Federal Privacy Act. I've chosen the GDPR because it is being pushed as the global standard, yeah, and it's also the one that we looked at in the paper, so that makes it a lot easier. But so you can see in Article 4.1 of the GDPR, just the first line of it, personal data is defined as information relating to an identified or identifiable matter or person. And then within the Privacy Act definition, you have a very similar definition. So you have information or opinion about an identified individual or an individual who is reasonably identifiable. Now there is a certain degree of interpretive disparity between these, although I suppose a layman looking at it would say that they're extremely similar. But long story short, the GDPR version, so the EU version of it, is interpreted extremely broadly, and the definition of personal information in this jurisdiction is viewed far more constrained, so it's much more narrow, at least on the basis of this decision, the Telstra decision. I'm happy to answer questions about how that is, but I'm going to move on to the sensitive data category definition because it's more relevant. So as I said, both the GDPR and the Privacy Act lay out different categories of information that are so-called sensitive. They require heightened protection because of that sensitivity. So in the GDPR, they're laid out in Article 9.1. So you can see that's data revealing racial or ethnic origin, political opinions, religious and philosophical beliefs. So I mean, there are categories. There's health data, biometric data, things like that, and there's a huge amount of similarity again across both of these definitions. So to kind of explain the problem a bit more, in this particular example, is the data inferred about the individual sensitive data or not? So this watch is designed to detect someone's emotions. But at what point does it become, say, health data, which is protected as a sensitive data category? Now, for this particular example, you could say, well, in any case, it's biometric data. It's probably going to be biometric data, so it's going to be sensitive data. But what if you continue with the other examples? So at what point, teens feeling insecure or worthless, at what point does that become a health concern? Is that health data, or what is it? At what point does it become the sensitive data that requires additional protections? So if you're in that sensitive data category, there are additional burdens that you have to satisfy. There are different conditions if it's just normal personal data. Yeah, so that's the kind of premise that we were looking at, and you can look at that through all the examples. Yeah, at what point would this become for political purposes that you're actually targeting, as opposed to a topical issue in the news that you're trying to figure out someone's opinion on or whatever, and given the fact that it could sway something. So that kind of blurring of the boundaries is extremely interesting. There was a study done by some computer scientists. Well, this one's quite recent, but they did one a few years ago as well, basically looking at Facebook advertising and trying to figure out, well, at what point are they actually processing, or is there a connection with the sensitive data categories as listed in the General Data Protection Regulation that I laid out before. Now, they're not explicit in that, they're not saying religion or religious beliefs or health, but you can see, there's suicide prevention on that list, for instance, which is very much linked to the health category. Or, you've got Bible or Buddhism or feminism. Yeah, so at what point does that become about a philosophical belief or a religious belief, etc.? And it's that kind of blurring of the boundaries, given the fact that there can be such extensive data processing that creates this kind of regulatory problem, you could say. So the reason, I suppose, the catalyst and a good reason to start looking at this right now is that the Privacy Act there's discussions around the potential reform of the Privacy Act. So you had the ACCC Digital Platforms Inquiry, which made several recommendations, and I suppose more justification as to why I looked at the GDPR. A lot of the recommendations in this report that deal with the Privacy Act are plucked directly from the GDPR, which makes my life a lot easier because that's what I'm familiar with, so it's been kind of an easier transition into analysing the Australian position. But it's an interesting one also because a lot of the provisions in the GDPR, because it is such a big piece of legislation, are still very much disputed. So just to kind of highlight some of these, So in Article 16A, you have the updated personal information definition, which would basically say that the point of it is to say that we need basically the GDPR definition of personal information. Again, I'm not going to dwell on that one, but what I'd like to go into a little bit just to highlight as well is recommendation 17, because it speaks to inferred information, and it raises this point of, like, what are we going to do with these inferences, given the fact that you can gather all this data that's seemingly innocuous at all, completely unconnected with any kind of sensitivity, and then it's processed through this black box and out pops a result that has an effect on something that's sensitive. So what do you do about this? Now, it's just kind of raising the issue. There's no particular question or suggestion about how it could be reformed. So it's kind of laying the foundation, I suppose, for the paper and what we would like to look at. Now, I suppose the first thing, one of the thoughts we had, well, should we just abandon the category altogether? Because if it means nothing at all, what are we going to do with it? Like, if you can just continue processing data that which reveals sensitivities all the time, then what's the purpose of the category to begin with? So we looked, I suppose, at different jurisdictions to see whether they all have this sensitive personal data divide or whether there's some that don't have it, and basically how they go about it. So now I'm not going to get into the historical bit of this, but this is just a table that kind of summarizes a little bit and shows, I suppose, some of the influence that was there. There are two historical instruments that everyone points to as being kind of key international agreements at the foundation of data privacy laws. The first one is the Convention 108 at the top there on the left, which was a Council of Europe initiative, so European Convention of Human Rights. So a very human rights orientated piece of our guidelines stemming from the right to privacy as protected in Article 8 of the ECHR. The other one then was the OECD guidelines, and obviously that has a far more economic swing to it as compared to the more human rights based Convention 108. Convention 108 has subsequently been updated, but if just, I suppose, speaking about historical foundations, that's the one you point to. Now, in addition to that, I suppose for the UK and for Ireland, you have European influence. I know I mentioned the GDPR before as being kind of the key piece of legislation and being pushed as the regulatory high watermark in terms of protection for data globally. The predecessor to that was the Directive 95/46/EC. So you can see the influences in Ireland and the UK, and it does have a sensitive data category because traditionally each of those has it, so it's just following on in the historical progression that is there. I'll come back to Australia in a minute because it kind of sits a little bit in between. The OECD guidelines then is interesting because it does allow for the creation of a sensitive data category within whatever regulatory regime there is at a national level, but it doesn't mandate or doesn't provide it within the guidelines. And you can see the countries that have been kind of inspired by that, so Canada, New Zealand, Singapore, they don't have one. So they just have an ordinary personal information category, and that's it. The US, again, is a bit unusual, and I'll move on to it. What's interesting, I suppose, about Australia is that it has traditionally straddled both. So it has a bit of a European UK influence in that there is the sensitive data category, but it also has been inspired quite a bit by the OECD guidelines. What's interesting about the Digital Platforms report is that it seems to be pushing it up, more towards the UK, EU, Ireland, as opposed to down the other line. Trying to figure out what to do with inferences, etc. But just generally across the board and the protections that are afforded, it seems to be kind of going more towards the EU standard. Now, the US kind of sits apart by itself. It kind of developed alongside what was happening in Europe at that time and in other jurisdictions, but it effectively offers a sector-specific approach. So there are certain US federal laws that protect certain areas, and then on top of that you have recourse to Section 5 of the FTC Act, provided it's a consumer-facing complaint. So there are just these sector-specific things as opposed to this broad omnibus, something akin to the Privacy Act or the General Data Protection Regulation. So a very different approach. Now, Paul Ohm has suggested that there are certain categories of sensitive data just by where regulatory movement has been in the US. And he lists them out, so sexuality, financial information, etc. And he's done a detailed mapping of the US legislation to say that in certain areas there are actually sensitive data protections. Now, what we argue is that it's kind of difficult to compare these a little bit. So this is an updated graph, or a chart compared to the last one, in that if you look at all the other jurisdictions, they also have an ordinary personal data category. So it's kind of comparing apples and oranges a little bit. So although they have all these sector-specific pieces of legislation that protect specific types of data, they would always be protected under the ordinary personal data anyway in all the other jurisdictions. So it's a bit of it's very hard to compare. So to kind of explain that a little bit, I've pulled out an example from another paper that I'm writing with the same authors and some other people. And this just speaks to how children's data might be viewed under the GDPR. So Paul Ohm would suggest, say, that children's data in the US, because there's this sector-specific piece of legislation, is protected as sensitive data, because there is this Child Online Protection Act, COPPA, as it's known as. In the GDPR, for instance, there's particular provisions relating to children around parental consent for the gathering of data and stuff like that. So there's still, there's still children's personal data. There's still a sensitive children's data category within that. So you can't really compare them in that, you can't just say that from the US sector-specific approach is it directly equivalent to that, because there are, you have personal data. Even if you say children's personal data is more sensitive, they still have a sensitive personal data category within the protections that are provided in the EU, for instance. And this is an interesting example because it's another part of the ACCC Digital Platforms Inquiry is to question whether we need protections for children as well. So it's a salient point, I suppose, for legislative developments in this country as well. Now, what's interesting about the US as well is that in recent years there's been quite a lot of EU influence at the state level. So you have some developments such as the California Consumer Privacy Act, which seem to be kind of moving towards the EU approach. Now, this is interesting from an Australian perspective, as Australia has kind of straddled both kind of approaches. They've had US influences and they've had European influences. But it's quite interesting to see at the state level there has been some development and movement towards recognizing at least that there are some forms of sensitive data. And you have, I suppose, the California Privacy Rights Act as well, which kind of builds on the California Consumer Privacy Act. But there seems to be this kind of more steady development towards recognizing this categoric kind of approach. Now, which kind of poses lots of interesting questions, because if there's a trend towards this categoric approach, but the technology is watering down the usefulness of this categoric approach, what does it actually mean? How, is that a good thing? Is there a merit to keeping the sensitive data category? What does the category actually aim to achieve? Which is, I suppose, if you can achieve it through other regulatory means, then that might be better, potentially. So some important questions like that. And, is it still worth striving towards that aim in an era where the boundaries between the categories are very blurred? Now, I suppose in trying to figure out, what do sensitive data categories try to achieve, my co-authors and I started to think a little bit about like, well, what has driven them historically, what's behind it, and what we found, I suppose, generally speaking, it's not a big secret or anything, but the risk of harm has really been at the root of sensitive data categories. So, you know, I suppose the chart on the right has different, I suppose, layers of harm that are there. But like, we do kind of acknowledge that, I mean, really at the core of these is, I suppose, human identity and human flourishing. So, you know, it really goes to, I suppose, the essence of what we want to protect in terms of our, spiritual harms or social and political harms or physical and economic harms that kind of make up why we want to protect these particular forms of sensitive data. Now, of course, any categorization like this has to keep in mind that the context is extremely difficult. Yeah, so you can't, you have to assess what the particular context is. So, one may slip into multiple categories, something that mightn't actually fit into a category, but in a particular context, because it's applied that way, might fit in, etc. So there's a degree of kind of, you know, it's an interesting exercise to kind of think about the categories and how they relate to harm, but it is difficult, I suppose, to put a pin on this a little bit. So, you know, I guess this question goes back to the very root of the question, but I'm going to give out the answer, I suppose, that we came to. It's not entirely satisfactory, I think. It's probably kind of a little bit of wait and see, but, you know, you have different approaches to how it's been catered for at the moment. Within the California Consumer Privacy Act, they specifically say that inferences are covered within the definition of personal information. So that, you know, inferences are personal information. It's not entirely clear how they would be satisfied within any kind of sensitive attributes. Within the GDPR, it basically, I'm going to work through an example to make it clearer, but it is that it can slip into the sensitive data category, but you have to be aware of the context and what is actually happening. So I'm going to just work through it to show you. So this is a diagram that I kind of went insane drawing, but you kind of, it's a kind of a simplified version of what would actually happen. So, you know, so you have various forms of, so you have a smartwatch here that is like detecting, based on, like, I suppose your health and well-being, whatever. So the whole point of this would be, say, for health insurance claims. Yeah. So you have a machine learning model that's based on training data that has been pushed through the model in order to create it, and then you have this various forms of input data. So you have a smartwatch which is feeding into whether, you know, what kind of insurance premium you should be paying, and you have all the sign-up information as well, which would be classified as personal data. So you have various forms of personal data which feed into the algorithm, which then spit out a result. So it's very easy to see on this side that all this was generally seen as the personal data side or personal information side, because it's everything that you're giving into the service, be that through the app or whatever. And there are different questions here regarding that. But and then I suppose the question then comes to the inferred data outputs. Yeah, so the machine learning model is generally dictated just by intellectual property law or, you know, trade secrecy. But you have all the inputted data, and then you have what's spat out at the end. So that's what's revealing. So at that point, then that may be sensitive data or not. Yeah. So I suppose that's the question. At what, like, you know, for the EU regulators and how it's been interpreted in guidelines, is that the output side of it, if it is a sensitive inference, it will come within the sensitive data category, and that's how they break it down. So the question really is, like, in that machine learning model thing, are you doing something which reveals a sensitive output? Are you doing something, you know, to actually infer something sensitive? So the ICO, which is the Information Commissioner's Office, has broken down different criteria as to how you would actually assess that. So it takes whether, you know, you have an intention to infer a sensitive inference, and then the other one is, I suppose, a reasonableness test. Should you have known reasonably that if you did this, you'd get a sensitive output. Yeah. Now, I don't want to kind of dwell on this too much, because we can. I think it's highly specific. But I mean, there are question marks as to whether intention, for instance, should be actually key or not. And here you can think about, like, how AI is thought of at the moment. Yeah, a lot of the time you get sensitive inferences or discriminatory impacts that you haven't anticipated at all. So, at what point does it become? Is intention really key to this or not? Does the purpose define sensitivity, or should we have more of a harm-based approach? So, should it be purpose, or should it, just focus on the outcome, I suppose, a little bit more, the result? So they're kind of like some of the key questions. But obviously from a regulatory perspective, they lead to difficulties in terms of how you could actually implement this in scope and also enforcement, given the under-resourcing of a lot of the regulatory agencies. So we do suggest kind of, that there has to be this kind of a hybrid approach to it, that it can't be just on the basis of intention, that there has to be some form of reasonableness to it as well. But I suppose that's kind of a little bit left undefined. It's kind of the end of the paper. We need to kind of figure out how we could actually map that a little bit better. So, the conclusions then for the paper is that, it can't be denied that the categories are blurring. It is a problem. Whether we should be kind of having a knee-jerk reaction now, we're kind of, I suppose, hesitant about that, because the sensitive data categories do serve a purpose. They're there for a reason. There is a risk that they will reduce into nothing because of the potential inferences that can be drawn. But, the harms that are associated with the processing of this type of information does merit some sort of special protection. You're talking about really sensitive categories of information. So, So I think I'll probably leave it at that, just to say, it's kind of still a little bit work in progress in that there's room for development, I suppose, in terms of how we would regulate this going forward. I suppose this paper kind of identifies the issue, I suppose, more than anything else. So there's still some room for future research in terms of how we could cater for it within, the regulatory responses. Okay, thank you.